Hello viewers, welcome to another lesson. Today we are going to exclusively focus on the 1991 Sierra Leone Constitution and its essential features. Now, the objective of every constitutional law class is to teach students to be able to identify and explain the institutions of governments, the nature, extent, and distribution of powers within those institutions, the forms and procedures through which such powers should be exercised, and lastly, to look at the relationship between the institutions of government and individual citizens. In order to begin the lesson proper, it is always important to begin with a proper definition of a constitution, especially when we are talking about constitutional law. Now, a very comprehensive, even though precise definition was provided by a very popular theorist, Vernon Bogdanor. He defined a constitution as a code of rules which aspires to regulate the allocation of functions, powers, and duties among the various agencies and officers of government, and defines the relationship between them and the public. It is therefore a document with special legal sanctity that outlines the roles and functions of all entities within the state. For example, legitimacy for Parliament to make laws can be traced in the 1991 Constitution. Or another bright example would be the power of the judiciary to exercise judicial function is as a result of the legitimacy the Constitution gave the judiciary. As for the last three constitutions in Sierra Leone before the 1991 Constitution, which can also be referred to as post-colonial constitution. To begin with the first constitution. The first constitution after colonialism was the 1961 Constitution, which can also be referred to as the 1961 Independence Constitution. The significance of this constitution is that it led Sierra Leone to independence. Another notable feature about this constitution was that it was the first constitution or the first law to define citizenship. Moving forward, the second constitution after the 1961 Constitution was the 1971 Constitution, which can also be referred to as the 1971 Republican Constitution. Now, the significance of this constitution is that it led Sierra Leone to become a republic, moving from the adopted Westminster parliamentary system in 1961 to a presidential system of government in 1971. And to the third constitution, we have the 1978 Constitution. The significance of this constitution is that it led Sierra Leone to a one-party state. And finally, to the 1991 Constitution, which has gone years unchanged, although there had been subsequent reforms over the years. The significance of this constitution is that it abolished the one-party state and introduced what we refer to as multi-party democracy, which we are currently working under. Now, how is a constitution cited? The constitution is cited by sections, subsections, paragraphs, and provisions. For example, section 40, subsection 1, paragraph A of the Constitution establishes the office of the President. Now, to illustrate that, section 40 is the main section, and the number following section 40, which is number 1, is the subsection, and there is a letter after the subsection which can be referred to a paragraph. So do not be confused when you see two letters two numbers, and a letter in a section or in a citation. So you cite this as section 40, subsection 1, and paragraph A. Now, a provision is detected when the phrase "provided that" is used in a section. So that is predominantly used in the 1991 Constitution. Now, to constitutional amendments that have taken place since 1991. There have been three significant amendments that have taken place since 1991, since the enactment of the 1991 Constitution. The first among these was the 2008 Constitutional Amendment. Subsection 3 of Section 64 was amended and replaced with the following. It states that all offences prosecuted in the name of the state shall be under the suit of the Attorney General and Minister of Justice, unless such offence involves corruption under the Anti-Corruption Act of 2008. And so what we had under the previous provision was that all offences that was prosecuted in the name of the state was under the suit of the Attorney General and Minister of Justice. There was no exception. So under the Amendments Act of 2008, an exception was created, which is the offences that involve corruption under the Anti-Corruption Act of 2008. Paragraph A of subsection 4 of section 66 was amended and replaced with the following. The institution of any proceeding in the court shall be done by the Attorney General and Minister of Justice, unless offences involving corruption. In 2013, there was also a constitutional amendment. Section 79 was amended as follows. It states that the Speaker of Parliament shall be elected by members of Parliament from among persons who are members of the House and who had served as such for not less than 5 years, or qualified to be member of Parliament and who had served as such for not less than 10 years and not less than 40 years. Subsection 2 and 3 of section 80 was also amended as follows. The Deputy Speaker must have been a member of Parliament and has served as such for not less than 5 years. Sub 3 of section 80 states that the election of a Deputy Speaker must be done at the first sitting of Parliament, or after a vacancy, or so after as may be convenient. The third constitutional amendment was in 2016. Subsection 8 of section 38 was repealed and amended as follows. It states that the registration of voters and conduct of elections shall be handled by Electoral Commission, and the registration of voters shall be reviewed after every 3 months, provided such review has not been done. Bylaws shall be conducted using the existing register of voters. This provision was completely absent in the previous provision under the 1991 Constitution. This ends this lesson. Please don't forget to subscribe, hit the notification bell for more of our contents. Thank you for listening.